Le député de Nickel-Belt.
I'm pleased to be here today to speak to issues surrounding Bill C-322, an act to amend the Railway Safety Act, rail crossing. While the government recognizes the complexity of railways and municipalities have to coexist, I would like to explain why we cannot support this bill. Essentially, this bill would introduce inconsistencies in the Rail Safety Act, which is the subject of a comprehensive statutory review that has been moved up to start in 2017 rather than 2018. This was announced on November 3rd, 2016 by the Minister of Transportation. This would provide an opportunity for our government parliamentarians to consider rail safety in a more comprehensive way than through PMBs designed to address one-off situations. This is very significant, Madam Speaker. To have the experience in my riding of Nickel-Belt, it's very important that these issues related to rail safety be addressed in partnership with communities and all levels of government. Together we have the responsibility to improve rail safety across Canada, and this PMB only seeks to address one specific situation. As a Member of Parliament, we all need to provide leadership in our communities to gather all levels of government to improve rail safety. Roundtable discussions with various communities, federal, provincial, municipal, Indigenous communities, the private sector, and Transport Canada are crucial. The statutory review of the Railway Safety Act that has been moved up by a year to 2017 is moving in the right direction. Avant tout, en plus d'un cadre réglementaire robuste et rigoureux en matière de sécurité, des mesures et des processus bien établis sont déjà en place, ce qui rendrait le projet de loi proposé redondant. Permettez-moi d'utiliser cette redondance en détail. Le processus actuel concernant l'enjeu central du projet de loi d'initiative parlementaire est l'ouverture et la construction de nouveaux passages à niveau. Pour commencer, le règlement sur les passages à niveau définit clairement les responsabilités de la compagnie de chemin de fer et de l'autorité responsable du service de voirie en ce qui concerne les passages à niveau. Understandably, with approximately 14,000 public grade crossings along more than 48,000 kilometers of federally regulated railway tracks across Canada, the regulations recognize and entrench the shared responsibility for rail crossings, railway companies, road authorities in provinces, municipalities, and band councils, and private crossing owners are each responsible for managing the safety at grade crossings. This is why Transport Canada encourages rail companies and communities to consult with each other to seek solutions through collaborative approaches. De même, le processus actuel en vertu de la loi sur le transport au Canada encourage les autorités responsables du service de voirie et les compagnies de chemin de fer à travailler ensemble pour convenir ou non de l'ouverture de franchissement routier, l'endroit de son ouverture et de la façon de répartir les coûts. Quand la compagnie de chemin de fer et les municipalités le conviennent, l'accord peut être déposé auprès de l'Office du transport du Canada et qui est un tribunal quasi-judiciaire indépendant prenant des décisions sur un large éventail de questions relatives au mode de transport des compétences fédérales, y compris le transport ferroviaire. These agreements usually include rates to be charged for work performed and specifically which parties are responsible for paying for this work as well as maintenance and liability. The file agreement becomes an order of agency authorizing the parties to construct or maintain the crossings or appropriate the cost as provided for the agreement. If a rail company and a road authority agree on a grade crossing but disagree on who should pay for the work, either party can ask the Canadian Transportation Agency to appropriate the cost of that project. When an agreement cannot be reached, the parties can access mediation services through the Canadian Transportation Agency. In most cases, the agency tries to resolve first complaints through facilitation or mediation. Mediators assist the parties in negotiating a mutually satisfactory settlement amongst themselves. When mediation is unsuccessful, the next step is for one of the parties to approach the agency in question. Adjudication can take up to 120 days, depending upon the complexity of the case. The agency's ruling under adjudication is legally binding and can include where crossings should be located, how many are required, conditions the crossing must be met, and a proportionate of the costs. Whether through mediation or adjudication, when crossings are required, Transport Canada provides safety-related advice to agencies before making their decision. All new crossings authorized by the agency must comply with the safety requirements of the Rail Safety Act and associated regulations such as the grade crossing regulations. Under the Act, the proponent for a new grade crossing must give 60-day notice to other parties involved. When all other avenues have been exhausted and where there are exceptional threats to safety, the Minister of Transportation already has the authority under Section 3201 of the Rail Safety Act to order a company, road authority, or municipality, or among other things, that corrective measures to address a threat to safe railway operations, including construction of a road crossing. As you can understand, the process in place is a rigorous one even before construction of a grade crossing begins. It goes without saying that the next steps in this process are just as rigorous. The grade crossing standards referenced in the grade crossing regulations set out the safety criteria for the construction, alteration, maintenance, inspection, and testing of grade crossings. These standards uphold safety at federally regulated crossings by promoting consistency and bring all federal crossings in Canada under one common standard. Transportation rules include monitoring railway companies through audits and inspections to verify that they meet safety standards under the grade crossing regulations. To do so, the Department conducts regular monitoring activities of rail works and operations, informs railways and road authorities of any safety deficiencies, and if required, takes appropriate action. In addition, as previously noted, in June 2015, the Rail Safety Act was amended to provide broader ministerial authorities to address safety risks, threats, or concerns. If the minister considered it necessary, in the interests of safe railway operations, specific measures may be ordered, such as constructing, altering, operating, or maintaining a railway work crossing would be included. While the emphasis for Bill C-322 to make it safer for pedestrians and cyclists to cross railway tracks is certainly worthwhile, road crossing issues are complex and multi-jurisdictional, requiring the involvement and cooperation of multiple players: the federal government, rail companies, road authorities, municipalities, and the member of the general public. The relationship between Transport Canada and the Canadian Transportation Agency strikes the required fine balance between road safety and the needs of the communities. Ultimately, the government is confident that the regulation and processes in place have the necessary rigor, flexibility to address the interest of this proposed bill. Merci, Madame la Speaker.